Our first case is State versus Bauler. But before we hear that, I do want to mention a couple of others that will be submitted without oral argument. Hummel versus Smith and Hiltz versus Smith are both submitted without oral argument. And we will begin this afternoon with State versus Bauler. And both attorneys, tell your high school. Thank you. You may begin.
I graduated from Central Dallas, which is a small town outside of Des Moines, sort of close by, class of 91.
Thank you. You may begin. We won't take that off your 15 minutes.
May it please the court, counsel. During a traffic stop, Kyra Bauler's car was subjected to a canine sniff, which resulted in a positive alert. Her car and purse were searched, and she was arrested. Because the evidence obtained during the stop and the searches was in violation of her rights under the Fourth Amendment and Article 1, Section 8 of the Iowa Constitution, her convictions for possession of methamphetamine, introduction of contraband into a correctional facility, and OWI should be vacated and her case remanded for further proceedings. Both the Fourth Amendment and Article 1, Section 8 protect effects from unreasonable searches. To determine if a search has occurred, the Iowa Supreme Court and the U.S. Supreme Court have held that they will consider whether the government they'll apply a proprietary test, and they will consider whether the government has trespassed on protected property and whether it was done for the purpose of gaining information. This property-based test is considered a baseline of protection from governmental searches that has been recognized since the time of the adoption of the relevant provisions. In this case, the dog sniff amounted to a search because both the handler and the dog repeatedly touched Bauler's car, rising to the level constituting a trespass, and it was done for the purpose of
trespass with you a little bit. So in Wright, we said trespass is really a violation of positive law unrelated to the Fourth Amendment. Here, I think your theory is trespass by chattel. So what statute or case would support that as a positive law that the officer could violate?
Under that, so I know there's been some discussion about the criminal. I think the criminal trespass statute arguably was violated here, but I think more importantly that I think both in Wright and in the Fourth Amendment cases, they talk about common law trespass as sort of what was recognized, what would have been prohibited at the time the Constitution was.
That's what I'm talking about too. And as I read Iowa case law, we do not have a common law cause of action for trespass by chattel. The jurisdictions that have recognized trespass by chattel generally require an interference with a possessory interest or damage that impairs use. So at least under the Iowa theory, positive law, it seems like that's problematic. Maybe under the Fourth Amendment, where they have a more general law kind of theory, maybe you're on better ground there, but address the Iowa part, please.
I don't know that I could point to a case. I've considered this under, my reading of Wright, and we might disagree about that. I didn't think that it had to be a specific case, that it was sort of these general principles of common law, and they would have been, I think when you look at Dorff, they also look that while Idaho wasn't founded at the time, the state didn't exist at the time the Fourth Amendment was enacted, they looked to these same principles to decide, and I recognize that's a Fourth Amendment case.
Go ahead.
Are you challenging the stop? I mean, your client was not speeding. She wasn't crossing over into the other lane.
To stop as well, correct.
Line up with tag.
Extremely informative on this. TAG holds that, if you look at how TAG, I guess really in all the cases that analyze whether reasonable suspicion amounts or exists to stop a car based on touching of the fog line or the white line, right? It depends on the exact circumstances. And what we have in this case is Bauler is followed for 15 minutes, which would equate to about 11 miles, And we have 3 touches of the center, the white dotted line, and 1 touch of the fog line, and she was driving slowly on a road without a minimum speed limit. And I think without more than that, there's no magic number of touches that get you to reasonable suspicion.
That the officer had run the plate and learned that she had some prior drug convictions. Does that at least inform like the slow driving and the weaving?
So those convictions are from 2015, and this is in 2021 that this is stopped. So it's not, it's not like these are pending cases or something fairly recent. Like these are years in the past. So it can definitely, like clearly that's something that was weighing on the officer's mind, but I don't think that's enough to get you to slow driving on a dark night. And these three touches without something else to show that the touches or the way she was driving was erratic, like tag holds and other cases, that there's a lot of very legitimate reasons that people will touch the center line or swerve within their own lane, and without something else in the officer's description.
License plate light that was out. The state points to that, saying even if they were wrong about that initial stop, the fact that the officer saw that light out later would provide justification.
That's yes. That, I think, first of all, I would, and of course on de novo review, I would encourage you, obviously you will, watch the video. I can't tell that the license plate light is out. Her description that there was one side that was very bright and it made it hard to read, and the other side was out, and then she says she confirmed when she stopped her, when I got close enough I could tell it was out, but then later in questioning she's asked, isn't it true there's only one light up above the license plate, like this car doesn't have it doesn't have 2 lights, it has 1. She says, I can't confirm or deny. And so I don't know that the officer, I don't know how much investigation she really did and how much you can credit her testimony that this light was out. And you watch the video and you see when the dash cam comes on, there's another car that was actually in front of the officer, and then Bauler was ahead of that car. And in the other car, if you look at the license plate lighting, they look the same. And it could be you have 2 cars in a row with license plate lights out, but you see that on the video and it doesn't look like what she said she saw. There's some other things I think, that she describes in her reports that don't quite match up with what's on the video. And so I think that has to be taken into account,
Back to the dog sniff, if I could. So let me try and frame the issue again. The situation was Ms. Bauler's vehicle had been stopped. The officer who made the stop is in the process of processing her other traffic violation issues, and then Officer Romiller brings the dog Ace twice around the vehicle, and we wouldn't have an issue if Ace and the officer didn't touch the vehicle, right? Is that correct? So the issue comes down to, is there some kind of common law trespass or intermeddling with chattel because Ace and the officer both touched the vehicle? Is that it?
Way Dorf decided held it, but that's the question. Is at common law, is this sufficient to...
To me, it might be something that's so minimal, it's not even as serious, certainly, as the Supreme Court held if you put the GPS tracker on the vehicle, then that's a...
There's no going into the plane of the car, correct?
If the snout had gone in, this, I don't think...
Cases, and there, Boucher or whatever, that came out very recently, where they had the video and the schnoz of the dog is definitely inside the vehicle. That's not our situation here. Okay.
On my understanding with the common law, when you're talking about trespass to chattel or intermeddling, the trespass occurs with the touching, it requires a physical touching.
With that hypothetical, if you're right, and then let's play out how things go. Suppose a bomb threat had been called in. It wasn't one at our building, but there was one at the federal courthouse, I understand, last week. And the police take Ace or another dog like Ace around to all the vehicles parked outside the courthouse and do the same thing, touch and have Ace put paws on the vehicle to search for bombs. Are you saying that that's an illegal search?
It's definitely a search, I would argue. Whether it's illegal, the next question is the search unreasonable? And I think, like, you look at other cases that find that in extreme, depending on what the level of information was about the bomb threat and what they were doing, like maybe there would be some exception for, imminent danger of a bomb exploding, that there might be some exception to the warrant requirement in those extremely dangerous situations. This is general criminal investigation that's happening. There's not probable cause to believe that this car has drugs.
It's closer to this case. So if you talked about touching, is it just the touching, or is it the fact that the dog put himself in a position to be able to actually smell the places where Officer Rommler is directing him to?
It's definitely, because that makes it has to be for the purpose of obtaining information. And so an inadvertent touch, the dog brushes by with its tail as it goes by, wouldn't trigger this.
Talked about like it seems to be clear that if you put the dog put his head inside, that is a trespass and would be problematic. What if the window was open a bit at the top? Or what was open? So the officer directed him to the top of the window, but he put his nose right up to it but didn't go in. Is that a distinction that really matters?
I think it is. I think at common law, if you're looking at common law trespass, sort of there's recognized a difference between going inside a chattel or inside property and in the close versus staying to the exterior. And that's why we recognize this sort of de minimis intrusion that, you expect that chattels that are out in the public and being used, and that things are going to get bumped and handled. You're standing in line, somebody bumps into your backpack or your suitcase, or somebody brushes against your car as it's parked. But when they're actually intruding at common law, according to my understanding and restatement, and that once you're breaking that plane and actually entering the property, there's no de minimis interference. You look skeptical.
You said there needs to be more. Isn't that a more persuasive argument? There needs to be more if there was only going over the fog line once. But from my summary of what happened, the driving 55 and a 65, the history of drug offenses, and maybe no one thing is enough, the plate lamp, driving 45 and a 65, crossing the center line multiple times, plural, and along the fog line for some time. Isn't that, each one of those things is the, quote, more you're asking for? Isn't that enough?
I disagree. I think that again, this is taking place. We look at these other cases and you see this sort of, suspicious driving or erratic driving happening within a relatively short period of time. We're talking about 15 minutes, 11 miles. Like, that's a long time to follow someone. And we don't know, if we knew more about these touches, were they sharp crosses and veering back? Was she changing speeds? Was there something else erratic? But it's like, just to touch a center line and come back, was this once every 5 minutes that something like this happened? Did it all happen at once? Like, some sort of character, like, this has to be reasonable and articulable suspicion, specific to this person. And so there's not a magic number that, over the course of 15 minutes, you hit this formula. Yeah.
One thing that has been mentioned is that that the state brings up is that your client was going so slow that it became a traffic hazard. I mean, isn't that enough on its own?
Again, we have the problem with sort of having to we don't have the video. We don't know, right? So we don't have anything objective to look at, but we know that we have statements from the officer that contradict what's in the video, or that are undermined by the video. And so sort of, I think you have to take, on a de novo review, you have to take what she says, what a little bit less, you have to take that into consideration. But the driving slowly, her description, the thing that undermines that, in my mind, like, it's true that She says traffic was trying to go around. It was a little busier than normal, but we're in 4 lanes, or 2 lanes going the same direction. Ms. Bauler's driving slower than normal. That's taken into account in the statutes that sometimes you have to drive slower than the flow of traffic. And what you're supposed to do is stay in the right-hand lane. And she was doing that. And so traffic getting around her, there's no description that people were honking and they couldn't get around. It was actually creating a hazard. Was it inconvenient? We don't have any real description, and we don't have the video to support what the officers said, which would be nice. And again, we're talking about a 15-minute time span. Was this the whole time? And also the officer followed her for 15 minutes, driving the same slow speed, exacerbating the problem. So that undermines the argument that this is really creating a hazard, because certainly she'd pull her over and get her off the road if it was really, rather than I'm going to do the same thing and make it that much worse if it was really dangerous.
Dog touching the vehicle. If I remember right, the touches here were like the dog's paws on the back of the car, or on the side, maybe it was the side, all around the car. So in terms of kind of causation of, did the touch facilitate the acquisition of information? How do you make that connection between the dog's paws touching the vehicle versus the dog's nose kind of pressing against the seam of the vehicle? I know some of the federal circuit courts have drawn that distinction and said, look, if the dog touches the car,
I think we have
suppression purposes.
with the dog, we have Officer Roemiller's testimony that the closer the dog can get, the better to smell it with, sort of thing. And so using the paws to get on there and sniff, and that's what this dog was trained to do when it sniffed. And so by the handler directing the dog to those places and then the dog putting the paws on, I don't know if the dog could have done it without touching, but this is how the dog was trained to smell. So it seems like that's how the dog is gaining information, and Officer Roemiller is gaining information as well. All right.
Summarize, you'll get to come back in a little bit. You got a red light. I know people think you have 1:40. It's actually growing, the time. Okay. That's okay. It's confusing. Okay. And Mr. Duden?
Thank you. Oh, I'm an Iowan by choice. Moved here for college and never left. I'm a 2012 graduate from Mill Valley High School, the Jaguars, in Shawnee, Kansas. So here we are.
Thank you for not forgetting.
Madam Chief Justice, and may it please the court. Today, the 3 issues presented for the court's review are all decided originally by the district court in the state's favor, and the same remains true today. Reasonable suspicion and probable cause existed and supported the stop, and therefore the stop was lawful. Second, there was no trespass under the canine or established canine free air sniff that occurred around the vehicle, regardless of the actual touch of the vehicle in question, as such incidental contact is not cognizable under a common law approach or under the positive law within the state of Iowa. And last, the issue was not preserved as it related to the search of Ms. Bauler's purse, and therefore is not before the court in a reasonable manner to be decided today, as it was merely used for a temporal demarcation or a marker in the record to decide whether before or after the search occurred was proper. Moving to the first issue, probable cause existed to support the stop here. Probable cause existed for 3 reasons as detailed within the state's brief. First, over the course of time that Deputy Vanderberg observed Ms. Bauler's driving, she observed a faulty license plate lamp. And despite whether or not that lamp could have been inconsistently described, it was noted and indeed confirmed during the period of time that Ms. Bauler was with Deputy Vanderberg while in her car before the citations and the warnings were actually issued. Iowa's traffic code notes that the tail lights and the tail lamps for the rear lights or rear-facing lights are at issue and are required to be illuminated properly. And so under Iowa's traffic code, the same remained true here. By not being easy to read, from a distance while driving on a highway speed, for instance, from State v. Griffin, decided recently by this court, the infraction.
So my understanding of the code is the lighting has to make sure that the plates can be read. That's the violation, right? The inability to read the lights, or read the plate, sorry. Yes. I thought she called in the plate while she was tailing her.
At some point in time.
That the lights were sufficiently good that she could read the plate?
The state would respectfully disagree, Your Honor, because first.
In if she couldn't read it.
The traffic infraction that included at going at highway speeds was when the plate would have been difficult to read, for instance. As the defense notes specifically within their reply brief, and indeed as the dash camera footage would show, as they neared to the stop prior to going into the gas station, for instance, the plate could have been easier to read. And so while the plate was ran when Miss Bauler went into the actual gas station area after she took the first on-ramp, it was not easy to read from a distance, for instance. So as Griffin would suggest in its final passages, the actual infraction was committed long before the stop even was necessary.
She couldn't read it from a distance and she only read it when they pulled into the gas station?
At the suppression hearing in volume 2 of the suppression hearing transcript, I believe at page 6, lines 20 through 25, that the overall portion was that it made it difficult to read. So during her testimony overall, if I remember correctly, the plate was difficult to read while she was behind the vehicle, even at a greater distance. Despite whether or not it became easier to read as they got closer, like in Griffin, that would go forward to believe that the violation had already occurred in question. So the testimony was, in fact, that it was difficult to read from a distance, but it was not the primary purpose for the stop in question in and of itself. Indeed, the district court decided the basis on a reasonable suspicion standard. 2 other instances for probable cause are provided as well. That is impeding the reasonable flow of traffic, which violates 321-285.
Move to the dog sniff, if we could. Is it your argument that this dog could have done anything sort of surrounding this car so long as it didn't go into the car? So, for instance, could it have jumped up on the hood and smelled the vent sort of at the base of the windshield? Or could it have climbed on top and sniffed the top of the sunroof?
The state's position is consistent with the federal application of the same principles, which are there are 2 primary limitations. The first is whether or not the officer directed the actual action to enter the vehicle, the interior sniff, for instance.
And again, we're still on the outside of this car. Assume that they jump onto the hood and smell the base of the, like where the windshield wipers are.
Well, the next inquiry would be whether or not they were directed to do so, which could go to reliability of the action.
Yes.
So that could impact the calculus from a perspective of reliability, for instance, whether or not the dog was properly trained, which was at issue, for instance, in State v. Carson. And
the dog was properly trained and directed just as the police officer did here. Instead of going up on the side with 2 paws, the dog jumps up with 4 paws and sniffs on top of this car. Is that okay?
The question would turn on whether or not damage resulted, technically. It would certainly be unusual for how the dog would operate in question. I wouldn't say necessarily that it would be an unreasonable action or a cognizable infraction as a trespass to chattels based upon even a positive law approach to the question. So could it have been a trespass? It could have been, it would likely constitute an entry onto or upon the property, much like Florida v. Jardines, for instance.
Okay, but the 2 paws are. Do I have that right?
The purpose still wouldn't necessarily be for the purpose of the search. So while a trespass could happen, the state's position is that the trespass theory or common law trespass theory for property rights principles cuts far too broadly within the perspective of a traffic stop context. And that's because it isn't so easily delineated, like the curtilage of one's home, for instance, in Florida v. Jardines. So the question of trespass to chattels being a cognizable infringement requiring damage, then the question would be like, here, we don't have any damage caused by ACE in question, and then the touch would just be incidental or de minimis.
It's like at least from my perspective, this is a much harder case for you or the state under federal law than state law. So I think in Wright, we were pretty clear that there had to be kind of positive law violations that required the officer to justify by getting a warrant. Federal law is not so clear, and they seem to have much broader concepts of trespass, like touching. So how do you deal with kind of, I think the toughest case for you is Hicks. I still think it's Arizona v. Hicks, and the court said that an officer in a lawful position who touches a stereo and reads the serial number, that's a trespass under the general law theory of Fourth Amendment, and it was done to get information, so that's a constitutional violation. That seems to be very similar to this case. How do you distinguish that?
Well, Hicks, the reason that the stereo was picked up in question was to read the serial number, I believe, as well. The purpose of the contact was to be able to view the information in question or actually commit the search. Here, Ace's paws weren't what was searching the air around in question or smelling the air.
Under at least Justice McDermott's hypotheticals, his paws put him in the place so that his nose could reach the area to do the search. I mean, clearly his nose is at least searching, right?
Has approved of similar human free air sniffs or a plain smell view of the actual incident or smelling the seams of a door, for instance, before.
Have we done it when the officer was touching the vehicle to put himself in a place to be able to smell it? If the officer stuck his head inside the car, could he do that?
So I believe this question was also what came up at Arrieta, for instance, in a similar context. The actual touch itself is what matters, separating the actual purpose of the search or how the search was done, for instance. What they were looking for here was a scent. What Ace was trying to smell was the presence of narcotics or drugs that were illegal.
Paws put him in a place so that his nose could smell better.
The de minimis contact of putting the paws in a place to smell, for instance, isn't what shifted it to be an unconstitutional infringement.
Cases like Richmond, I think you decided, from the Fifth Circuit, that's the one where the officer just touches a tire and realizes that there's something besides air in the tire. How that's pretty de minimis, but the Fifth Circuit found that to be a violation under Jones and Jardines.
Richardson in the Fifth Circuit out of 2019 found it to be a potential common law trespass. They did find it to be a trespass, that's true. They found it to be a reasonable trespass and therefore not a constitutionally recognized infringement.
Under federal jurisprudence, I think, though, because it wasn't well known, or because it wasn't exclusive, but it was still a trespass, right? What was the what was the basis for its reasonableness? Because I'm blanking on that right now.
It was found to be reasonable because at the end of the day, it was for the safety of the unbalanced tire, why the original stop had gone in the first place.
But it was still de minimis. So what makes Ace's touch of the car reasonable here?
Ace's touch of the car in and of itself was not what led them to smell the presence of narcotics. Getting closer to the scene, for instance, like State v. Stevens, which was decided by this court, didn't seem to express displeasure or disinterest.
Involved, that had to do with the passenger, had nothing to do with the dog sniffing inside of the car. That issue was the passenger, so it wasn't even the driver that was at issue. But if you go back to Hicks, Justice McDonald was just talking about, it wasn't the officers touching the turntable that led him. He didn't read it by braille. He had to he moved it so he could see it with his eyes. Why is that not the same thing with Ace using his paws to put himself in a position, kind of like the officer in Hicks used his hands to put the turntable in a position so that he could then use a different sense, his eyes or his nose, to then gather the information he's looking for?
Distinctive characteristic would be that the smell itself was still emanating from the car, and there was no reasonable belief that the actual smell in question, you can't have a right to the smell or scent of narcotics.
It's far, far afield from this thing. I mean, Hicks involved a warrantless entry into an apartment to investigate a shooting. While there, the cop then conducts additional the only reason the officer is allowed to be there is the exigency of the shooting. While there, the cop decides he will start looking for stolen property by flipping over a stereo or a turntable. Here, the analogy would be if you took Ace into the apartment and Ace started sniffing around in the apartment while you were looking for investigating the shooting. That's a lot different, isn't it?
As pointed out within the discussion of the history, the home is first among equals.
The entry into the home is conceded to be lawful in Hicks. The constitutional violation is the physical touching of the stereo. So from a constitutional perspective, the officer standing outside the car and the officer in the apartment in Hicks are both in lawful positions where they're entitled to be. I mean, that's the relevant issue, is where was the officer positioned in terms of his right to be there, right? The home entry had nothing to do with Hicks. Scalia was very clear. The physical touch of the stereo itself was the violation.
Justice Scalia also mentioned, though, from the perspective of why it was improper was because there was a lack of reasonable probable cause to actually pick up the stereo in question and search for the actual serial number.
Case for Ace to be searching for drugs. I think that actually brings up a really important point in this case. Are you arguing that they had any indication of drugs inside the car to support Ace doing his sniff?
No, and none was required.
I just want to make that point clear because I think that that's an important part of understanding kind of the cabias, and you can take the dog and do a free air sniff while you're otherwise have the car stopped for a completely different traffic infraction. But that kind of brings up the point that Justice Scalia was making in Hicks, I think, which is that once you're lawfully in a place, you're really kind of limited to the purpose of your lawfully being there. And so while walking him around the car might be okay because he's not touching it, Jones and Jardines makes more clear that once you do touch and you do use physically intrude on an effect, and a car is an effect under Jones for the purpose of gathering information, now you have a much different analysis that expectations of privacy have nothing to do with. Is that right under Jones and Jardines?
Jones speaks to the definition of trespass being the physical occupation of the space in question. Here, an incidental touch by a dog's paws or an officer's hand is a de minimis contact more akin to Oliver Mendez from the Eighth Circuit, for instance, or closer to United States.
It's pre-Jones, wasn't it?
It was, yes. It's still been cited and relied on for the principle of what Jones has to speak to.
Make clear that expectations of privacy have nothing to do with a property-based search.
Reasonable expectations of privacy are still evaluated even under the Wright standard, as we've discussed it here.
Under the Iowa standard, but what we did in Wright is very different, I think, than what the Fourth Amendment has been doing.
Certainly, Wright would follow a similar context as it's been discussed here. Seeing that my time is ticking up, may I briefly answer? Thank you, Madam Chief Justice. Wright parallels more of an analysis under United States v. Richardson, for instance, than it does United States v. Jones. That reason being that Jones was an occupation of a space by attaching or affixing a GPS device onto a vehicle for 28 days absent a warrant of the wife of an individual being investigated. The 28-day term, the limit in the attachment onto the vehicle, is something that the physical occupation of space was discussed even in Arrieta's purpose, that an incidental touch, a de minimis contact, absent something more, is what made it unreasonable. The standard for reasonability in Jones came from not just a positive law aspect, but whether or not people would believe using their individual reason and common sense and accept that it was a reasonable action by law enforcement. A 28-day occupation of the space by attaching something to a person's car without them knowing was found to be unreasonable.
But Jones didn't turn on the fact that it was a 28-day. In fact, Jones actually distinguished Knotts, and there was another case that I can't think of, that said that it was okay, that your movement, even your movement in public, is something that is available to be seen, and so you don't have an expectation of privacy in that. Jones distinguished those cases and said that on a property-based search, the expectation doesn't matter. So it didn't matter that it was a 28-day search. What mattered was that they actually attached the GPS to the outside of the car.
If I may answer, Madam Chief Justice. Thank you. Jones has been relied on for the purpose, just as United States v. Richardson cites it for the same principle, that something more is to be done here. As would be articulated from Jones and Jardines, for instance, or even under Carpenter, the trespass itself doesn't get you to the end, and that's true under Wright as well. But the standard overall is the property-based interests from where Wright ends only injects the same confusion that these questions ask us now, that there's no bright line standard for a reasonable expectation of privacy because we can't determine whether or not a clear test for trespass or even a definition of the same applies in every instance. Certainly the federal circuits and the federal courts post-Jones have not relied on it in the context of a traffic stop, for instance, where a limited contact or a de minimis contact, as cited later on, means anything more than what it is. A short, brief interaction between law enforcement in a place where they have the right to be on a public roadway to ensure that there's no further criminal activity afoot. And here, the reason the state asks for right to be overruled, or at least limited to the context of one's home, is because this confusion only injects greater uncertainty into the Fourth Amendment's purposes. And it becomes somewhat academic, maybe, after we evaluate the reasonableness under today's positive law standard. And for that, we ask the court affirm the district court's judgment for the remaining reasons cited in the brief. Thank you, Your Honor.
Thank you. Just a couple things. I wanted to touch on the stop and the license plate light and the reference to 321, 388. And just to point out that her testimony that it was difficult to read at a distance, we have nothing in the record to support at what distance she was observing the car. The statute requires it has to be legible from 50 feet. And so that, just sort of undermines, I just wanted to point that out, that it's very specific. That statute's very specific about where it has to be legible from. And her description and her reports don't specify what distance she was falling a ways back. And as to the dog sniff, I think we've got under either Constitution, and certainly I think under the Fourth Amendment, as Scalia said, like the trespass test lets easy cases be easy, and it's usually pretty easy to know if somebody's trespassed. And I think if...
how is a trespass occurring here? I've never seen a case that this particular kind of thing would amount to trespass to chattel. I've never seen a case.
I think if you rely on the restatements and Blackstone and Prosser, the sort of description of trespass to chattels.
Yeah, but all the interferences they describe are much more substantial. And then as far as Hicks, maybe there's different views, but what I read Scalia saying right up front is this case involves a warrantless entry into a home and the plain view exception, and under the plain view exception, you can't turn over a stereo and look for serial numbers. That's very different from here. There wasn't a warrantless entry into a home. It's an area where the cop and the dog are entitled to be. It's a public area.
Entitled to be around the car, but the entire, under the Constitution, we're protecting effects, and we're not just protecting the inside of effects, the entire
You can't invoke Hicks and then add the, say, and then disregard where the so-called intermeddling took place. The reason why the so-called intermeddling was a problem in Hicks is because of where it occurred and that the cop was only there because it was a very limited exception that allowed him to get into the home, right?
Even with Hicks, I think Jones answers this question. Like, Jones is dealing with a car with an effect that's out in the public. And so even if Hicks should be held to its facts, Jones, supports this.
That also strikes me as very different. So Jones, you're putting a GPS tracker on a vehicle. I think, most people here around in this room own cars. I think most people would view it pretty differently if somebody stuck a tracker on their vehicle without their knowledge and left it there and to gather information, whether they were a private person or a cop, and somebody who just brushed by the vehicle with their dog.
I respectfully disagree with the characterization that this is brushing by the vehicle with the dog. I think if you walked out...
The vehicle with the dog.
Paws and claws. Like if you walked out and a dog was jumping on your car like this, I think any of us would be furious, rightfully, that if a private person came and directed their dog to jump on your car.
And whose dog he's allowing or even directing to jump up on somebody's parked car, could they be prosecuted for trespass, for criminal trespass?
Arguably, they could under this. Under our trespass statute, I think if you enter onto property and deface it or damage it, that definitely.
Their dog didn't damage this car, right?
Record that, I mean, she's
damage, right?
Commenting as she watches this dog jump on her car that she can see the scratches and it's scratching her car. And anybody who's got dogs, if a dog jumps on your car, it's going to scratch your car.
Sir?
That they said under federal law, under Fourth Amendment, you don't need damage.
Right, if we're talking about the Fourth Amendment. I mean, same thing for the Richmond and Thomas from the Ninth Circuit. They talked about if you putting the dog in the back of the truck to be able to smell the toolbox in the back of the truck was likely a Fourth Amendment violation. It wasn't a problem there because officers didn't know, and so the exclusionary rule didn't apply. But it seems like that the federal cases that have tried to apply Jones and Jardines since that time have been pretty minimal have followed Jones to say, any kind of touching on the outside of a car, as long as it's done for the purpose and it facilitates.
There's no damage required. It may not, like they acknowledge at common law, you may not have an action, you may not recover unless there's damage, but the trespass occurs with the touching, and the trespass affects the legal relationships of the parties. Normally, one of your proprietary interests, possessory rights, is the right to exclude and the right to stop someone who's jumping on your car with claws and potentially scratching it. I think just common sense would tell you that that there's going to be damage of some kind to the car. Whether you would recover, I don't know. I see my time is more than out again. For the reasons argued today and in the brief, we respectfully request that her convictions be vacated and the case remanded for further proceedings. Thank you.
The case of State versus Bauler is hereby submitted, and we will now move on to the case of State versus Bailey.